Welcome to Hard Talk. I'm Stephen Sacco, and I am just one of roughly 800 million Europeans whose fundamental rights and liberties are supposed to be safeguarded by the European Court of Human Rights. It's an institution steeped in European idealism and ambition, but does it work? Well, my guest is the president of the Strasbourg-based court, Dean Spielmann. Critics condemn it as undemocratic, unaccountable, an infringement on national sovereignty. Do they have a case? Dean Spielmann, welcome to Hard Talk.
Thank you for inviting me.
Would you accept that as far as European citizens like me are concerned, your court is actually extraordinarily powerful?
Yes, indeed. I would accept that without any reservation. Our court is there to be powerful, I would say. That's what the original drafters wanted when they set up the convention.
Is it troubling to you then that I would bet you that if I left this studio and went out on the streets of London, or indeed any other big European city to be honest, and I asked people exactly what the European Court of Human Rights was for, how it was constituted, how it related to other European and national judicial authorities, I bet you most people wouldn't have a clue.
Well, I mean, that is very often the case with international relations, with international law, with other questions that people sometimes do not know, but I think it's very important to explain.
But for courts to be credible and to be accepted as part of a judicial culture, don't people have to sort of understand the basics of what they are and what they're for?
Absolutely. Absolutely. They need to understand, and I think everyone should do his or her own best to explain the functioning of the European Court and the functioning of the European Convention. We, on our part, we are doing that. We have programs in Strasbourg to explain. We have many visitors who come to the court to visit the court, and we are more than happy to explain the system, how it works.
Okay, well, let's make a stab at doing it for ourselves. I mean, would it be fair to draw a very loose parallel with the US Supreme Court in the sense that when it comes to human rights and basic individual liberties, you are the ultimate judicial authority for all of the member states of the Council of Europe, and that is 47 nations, pretty much all of Europe. You are the ultimate judicial arbiter.
The Convention entrusted us to interpret and to apply the Convention, but I would be very reluctant to see our court in the same way as the Americans see the Supreme Court. We are not a Supreme Court of Europe. We do not quash decisions of national courts. We do not take the place of the legislature, although we find violations from time to time. Often,
yes, so in fact
yes,
you do overturn decisions taken in national parliaments. You challenge them, you decree them to be violations, and you demand recourse, you demand that change is made.
We say that in particular cases there has been a violation of the Convention. That's what the drafters of the Convention wanted us to do.
And the other point of parallel, surely, is that there is no comeback from your decisions. There is no ground for appeal, nowhere to appeal to. Yours is the final decision.
It depends what you mean by the final say. Chronologically, it may well be the case that we intervene at the very last moment when all the domestic remedies have been exhausted, and that is a requirement of the Convention that applicants need to exhaust local remedies. But I attach a great importance to the dialogue also, especially with domestic courts and in particular with Supreme Courts in Europe.
Well, you call it a dialogue, but in the end one has to define where ultimate power and authority lies, and you're being a little bit shy about it, but it ultimately lies with your court. You can demand that your decisions be acted upon at a national level.
That's absolutely correct. Our decisions are binding decisions. The Convention says it very clearly. Our decisions need to be implemented in the domestic system. However, how decisions are implemented is part of the marginal appreciation also. The law can be changed or the case law can be changed, but my point is that we do not quash decisions of domestic courts. So I think that the discussion, who is supreme in Europe, is not the correct way of putting it.
Well, I suspect we'll get back to that when we talk about individual cases, which we will in just a moment. But just another thought. We've sort of agreed that it's a very powerful court. You say rightly so because of the importance of the Convention on Human Rights in Europe. But there's another big picture way in which I see the court to be failing, and that is you don't appear to have the resources to be able to match the requirements placed upon you. You have tens of thousands of cases in your backlog. You have thousands of new cases coming before the court every year. You only have 47 judges, one from each country, and it is plain that the resources you have, the capacity you have, can't cope with the demand.
Well, I mean, it is always a problem of resources. That's absolutely true. But with the limited resources, we do quite a good job, I would say. Our registry is extremely efficient. Let me give you an example. By the end of 2011, there were 160,000 cases in the docket. Now, the latest statistics, which were elaborated a few days ago, show that we cut it down to about 98,000 cases. So we are now below the threshold of 100,000 cases pending. Is that
supposed to be good news for the people who are involved in those 100,000 cases, which is still the backlog? You're telling me they should be pleased about that?
I think that it is very good news that we deal more efficiently with the massive influx of cases. You know that everyone can send a petition to Strasbourg, and we need to deal with this petition. That's the right of individual petition. It is a cornerstone of our system. So we need to find ways to deal with all those cases efficiently, and we have done a great effort over the last 2 years, and thanks to the registry in particular, but also because single judges may now decide on those issues, we are able to cope with the backlog.
Well, if you think coping is sort of having 98,000 cases outstanding, I suppose that's true. Isn't another problem that you have to acknowledge that certain countries within your council membership, thinking maybe Russia, Ukraine, Turkey, maybe even Italy as well, have judicial systems which are so poor, so dysfunctional, that vast numbers of complainants, as soon as they don't get satisfaction in the local courts, come to you saying that, frankly, the local court system isn't capable of delivering individual justice. That's a profound problem.
Yes, and I would agree with you if our court would be considered as being a court of appeal, a super European court of appeal, which is not the case. However, many of those cases raise very fundamental human rights issues, especially coming from countries which don't have the same democratic tradition as other members of the system. But still, I mean, even concerning countries you mentioned, the backlog has been reduced over the last 2 years, considerably reduced over the last 2 years.
All right, so listen to you, and it sounds as though things are really going jolly well, but it seems to me that your court perhaps faces the most concerted challenge to its legitimacy that it's faced in 60 years, and the challenge in particular comes from the United Kingdom. Would you accept that?
Well, I accept that there is an ongoing discussion here in the United Kingdom, and I must say that we are a little bit disappointed that the challenge comes from a long-standing member of the system. You know, the United Kingdom has been instrumental in setting up the system. The drafters of the convention were British lawyers, not only British lawyers, but David Maxwell-Fyfe, for instance, played a major role in setting up the system. So you understand that we are a little bit disappointed that now, 60 years after the system has been made in place, question of parliamentary sovereignty arise.
Well, surely, you use the word disappointed, surely you should be worried that Britain, with its tradition, a fine, proud tradition of legal integrity, of taking human rights and liberties fundamentally seriously, you should be worried that such a country now looks at the role you play in European human rights and liberty issues and sees a fundamental problem.
Yes, but I think that it depends also how the judgments we deliver, in particular concerning English cases or UK cases, are explained to the public. I mean, there are two judgments that have been heavily criticized, but I mean, it depends also on the explanation of the judgment, how you explain to the public what the court has said, or more importantly even, what the court has not said.
Yeah, well, we'll get to individual cases, because I suspect we're going to talk about the same two cases. But before we get there, it's the principle I'm getting at. I mean, the Justice Minister here in Britain, Chris Grayling, said the European Court of Human Rights has lost democratic acceptability. He says that the government in this country is going to use legislation to ensure that the Supreme Court in England and Wales is actually the Supreme Court, that you can't, in the end, second-guess decisions made by the constitutionally formed Supreme Court of this country.
Yes, but you know, the very idea of international fundamental rights, as it has been set up by the Convention, is precisely to entrust the interpretation and the application of the European Convention of Human Rights to an international court.
Yeah, but the point that not just politicians but judges make in the UK, quote one appeals court judge, Judge Laws, he says, the problem is that you push precedent and Strasbourg case law as something which the United Kingdom has to regard as inviolable, when in fact the UK has signed to the Convention but has not signed to recognise the status of precedent, case law, built by your court. There is a fundamental difference.
I think that the Human Rights Act strikes a very careful balance concerning precisely the problem you raise. What is the relation between domestic courts and the European Court of Human Rights? The Human Rights Act is a marvelous piece of legal engineering, if I may put it like this, precisely because it says that domestic courts take into account our case law. That does not mean that our case law is binding precedent for the Supreme Court, but the Supreme Court has done over the years a marvelous job in taking into account our case law and applying the same principles as we do. You know, Lord Bingham once said, no more, but certainly no less. And that's precisely what the Supreme Court has followed over the years. There are even cases where the Supreme Court went further than what we require as minimum standards in our case law. And that's what I mean by judicial dialogue.
Well, you make it sound like a well-oiled judicial machine with the national and the supranational European courts working in accord. The fact is, it just ain't so if you look at the United Kingdom and look at challenges that you face today. Let's take the first one. That is the issue of sentences for the most heinous crimes. In the United Kingdom, the government makes it plain that it wants a whole life sentence to mean a whole life without review. Your court has struck that down. The British government is determined it will stand by what it means by a whole life sentence.
Yes, here again it is the way how you present our judgment in the Winter case. If you ask people in the street, do you agree that the most heinous criminals should spend the rest of their life in prison, most of your interlocutors would say, yes, of course. But that's not what the court has said. The court has not said that you cannot sentence anyone to a life imprisonment. What the court has said is that after a certain amount of time, you need to offer some kind of review. So it's more the possibility to have the sentence reviewed after many, many years that was at the heart of the case. And we did not say that life imprisonment as such would be incompatible with
Well, you
Convention.
may well know that in the last couple of days, the Justice Secretary, Chris Grayling, has sent a note to the Council of Europe saying the British government has no intention of backing down on this. The whole life tariff will remain without review. So what are you going to do about it?
Well, I mean, if that is so, of course, Mr. Grayling must be aware that not executing a judgment of the European Court is inconsistent with international law, to begin with, and with the Convention.
So what are you going to do about it?
Well, I mean, we are probably getting other cases, and we will decide on the merits of those cases. But that is not the question. What the Committee of Ministers is going to do, because the Committee of Ministers has the obligation to supervise the execution of our judgments.
Right, well, we'll come back to sanctions you might be able to place on a government which refuses to act upon your rulings in a second. But let's just look at another case, that of votes for prisoners in British jails. The prisoners in Britain do not have the right to vote. Your court has decreed that that's unacceptable, a violation of human rights standards. Again, the British government has made it plain. It's prepared to talk about some minor adaptations, but the fundamental principle, a ban on prisoners voting, is not negotiable.
Well, I mean, again, we didn't say that prisoners should all get the right to vote. What we said is that a blanket ban preventing all prisoners from voting is inconsistent with the Convention. And incidentally, this debate in the United Kingdom has now led to a report by the Joint Committee, and the Joint Committee takes the same view, that a blanket ban would clearly be inconsistent with the Strasbourg case law, so there are alternative solutions.
Parliament voted roughly 230-odd votes to 20-something votes that it would maintain the ban on prisoners voting. Does that not matter to you?
Well, of course it does matter to me, and I really hope that after reading the report of the Joint Committee and after having a very thorough discussion, as always, here in the United Kingdom, that a majority of parliamentarians might reconsider their position.
I dare say the majority of parliamentarians would agree with Damien Green, a minister actually of criminal justice and police in this country, who said that British laws should be made in the British Parliament.
Yes, but I mean...
You're de facto making British laws in Strasbourg.
No, we are not making British law in Strasbourg.
Well, that's precisely what you're doing, because you're saying that the British law as it currently stands cannot stand.
We are saying that a blanket ban on prisoners voting is a disproportionate inconsistency with the Convention. Now, I mean, there are various options on the table, and of course parliaments enjoy the widest margin of appreciation to find one of the solutions. So I don't think that Strasbourg micromanages parliamentary work.
You've got yourself into a heck of a confrontation here with the UK government. David Cameron, the Prime Minister, said that it made him feel physically sick to imagine that prisoners would be given the right to vote. Looking at some of the most popular newspapers in the UK, they've been running headlines in the last couple of months talking about terrorists, rapists and paedophiles getting the vote. I'm sure you've read the opinion polls that show a very clear majority of British people do not want prisoners to get the vote. You have got yourself, with your court, into a full-on confrontation with not just the British government, not just the British public, but the entire British system.
Well, once again, it depends how you explain our judgment to the public. I mean, if you say, would you agree that rapists and ex-murderers should be deprived of the right to vote? I mean, it's clear that many people would say, no, of course not. But that's not what the court has said. The court has said that a blanket ban, an unnuanced ban, would be inconsistent with the Convention. So there are various options on the table.
Does it not worry you that this isn't just political, that some of the most senior and respected legal minds in the UK accuse you, and I'm going to quote Lord Sumption, who sits on the Supreme Court in England and Wales, of becoming, quote, a flag bearer for judge-made law extending well beyond the text which you are charged with applying?
Yes, I mean, Lord Sumption, I read his very interesting lecture he delivered in Kuala Lumpur. I mean, he referred to the notion of a living instrument. We have constantly interpreted, and domestic courts have done so as well, the Convention as being a living instrument. And Lord Sumption questions and criticizes this approach. Now, it is clear that the draft of the Convention did not envisage the development of technology, for instance, or bioethics, or DNA questions. And it is clear to us and to domestic courts also, all over Europe, that the Convention needs to be interpreted in the light of changing circumstances. However, and that's very important, and that's sometimes misrepresented, we do not create new rights, and I want to be very, very strong on that principle. We interpret the Convention rights in the light of changing circumstances without creating new rights.
That's not the way that many British judges, as well as politicians, see it. But let's get back to this point about sanction, about punishment, if Britain refuses to toe your line. Chris Grayling, again, Secretary of State for Justice, says that ultimately there is nothing you can do. And ultimately, even if you impose fines upon the British government doesn't have to pay them.
Well, I think that not implementing, not executing a judgment of the European Court would be and is a violation of international law. And the Joint Committee in the report I mentioned earlier made that very clear.
Would Britain then have to be thrown out, in your view, thrown out of the Council of Europe if it refused to acknowledge and abide by the rulings of the European Court on human rights?
Well, that is a political question, and as a president of the court, I do not want to enter into the political arena. You must understand.
But it's very germane to your entire message and the power you have to win the argument. I mean, the British government again says it's not actually necessarily the case that Britain would be chucked out of the Council of Europe. I want to know what you think.
Well, I mean, it is, of course, a problem if a country with a long-standing tradition of protecting human rights, and I would like also to pay tribute to the work which is done by the United Kingdom in the rest of the world promoting human rights, that this country would not comply with the rule of law.
But that's precisely why it may, with all due respect, be a mistake for you to push these particular issues like the rights of prisoners to vote, because you could stand to lose more than the British government because of Britain's reputation as a home of good law, of integrity, of human rights respect. It could be that some countries will look at Britain standing up to your court and say, well, you know what, if Britain can stand up to the European Court of Human Rights, so can we. And what's the downside?
You're absolutely right with your analysis concerning other countries. But that is not a reason for us not to interpret or to apply the convention according to our principle. We would introduce double standard. You see, we would take different decisions when long-standing members of the Council of Europe are concerned, and take more strong decisions when other countries are concerned. And that's precisely what the European Court never wanted to do, to apply double standards.
But what we could be seeing is the beginning of the unraveling of this 60-year experiment in pan-European human rights justice. Because it's not just Britain. I mean, for example, the Russians right now are saying that they see no reason to abide by your rulings on some of the issues concerning gay rights and the treatment of homosexuals. Very loud noises in the Russian parliament along those lines. It could be we're about to see the fragmentation of the European Court of Human Rights.
But if you mention this problem raised by, you say, Russia, with this argument we could also then adopt a different case law concerning Russia or concerning any other countries. We never did that. We never applied double standards. So,
but if you lose Britain, if Britain walks away from the European Court of Human Rights, then it becomes much less difficult for a country like Russia to walk away too.
Of course.
And you are very close to facing that danger.
What I'm saying is, if Britain would leave the European Convention, it would be a political disaster.
For whom? For Britain or
everyone,
for you?
For everyone who is dedicated to the effective protection of human rights, not only in Europe, but also in the rest of the world, because we have a unique system of protecting human rights. A very powerful system, yes, admittedly, that's true, but it has worked so well over the years. It has given Europe so much, and also the United Kingdom.
So what is your warning to David Cameron, whose party right now is still actively contemplating walking away from the European Court of Human Rights?
My warning to David Cameron would be that Britain should be very careful not to lose its credibility by taking such an important move, and it would not be in the interest of effective human rights protection, and I'm personally convinced that it would not serve the British interests.
Dean Spielmann, we have to end there. Thanks for being on Hard Talk.
Thank you.